Welcome to the Art of Arbitration, where we explore the world of ADR. Today, my guest is Duncan Bagshaw, a partner at the Howard Kennedy Law Firm in London. Thank you for joining us today, Duncan. I appreciate it.
It's a pleasure. Good to be here.
Thought we would start with a little bit of background. Tell me first a little bit about your firm, how you got there, and then we'll talk more specifically about your practice.
Sure. As you say, I'm a partner at Howard Kennedy in London. Howard Kennedy is a medium-sized firm by London standards, but quite a large firm by global standards. We have about 300 lawyers, and we offer a full-service practice covering all areas of legal work. We have a firm culture which rests upon thinking smart, being yourself, and talking straight. And that's what we try and offer to our clients. We have some specialized areas of practice. We're particularly strong in the real estate area. And we also offer a very strong dispute resolution service, both in the area of commercial disputes and also business crime and regulatory, media and reputation management, and insolvency related disputes. So that's a particularly strong part of our team. How I got there is that I started life as a barrister in the traditional English way. So I was a self-employed individual advocate practicing in a chambers with other barristers. After about 10 years, I decided I wanted to focus on international work. I resolved to join a law firm, but just as I was about to make that move, I got an opportunity to go and work overseas in Mauritius, which we'll perhaps talk about a little bit later, running a new arbitration centre. And once I'd done that, I came back to London, and I knew then that all I wanted to do was arbitration, and principally I wanted to focus on the African region as part of an international practice. Well, so I joined a law firm for that purpose.
Let's talk a little bit, maybe out of order, but let's talk a little bit about that secondment and how that came about and what you were doing and how that led you to the field you are now in, which is, one of the well-known international arbitrators in the world. So
it was a very fortunate piece of timing. As I say, I was about to go and join a medium-sized or large law firm. That time, the government of Mauritius was looking to enhance its environment and offering for dispute resolution. Mauritius is a place that's often been a place for company incorporation, for global business as a seat of companies or as a headquarters for international companies. And the government took the view that it would be a nice complement to that service to have business dispute resolution services on the island operating at an international level. So they asked the London Court of International Arbitration to help them set up a new centre. And one of the things they wanted was an independent international arbitration practitioner who would come and help them develop the procedures and the infrastructure, and also go out to the world and talk about what they were doing and promote this new opportunity as a place to choose to resolve disputes. So I went to set up that centre. I was there for 3.5 years. And it was a wonderful experience, mainly because Mauritius is a wonderful place and the people are warm, intelligent, educated, interesting, and very culturally diverse. It's a place that's made up of a whole mixture of cultures who've come together to form a country. So it was a wonderful experience, and it really gave me a specialist experience of arbitration and how the industry works that I didn't have up till that point.
And is the system in that country similar to the system in the UK? In part because that's what they wanted, in part because you were a significant part of building that structure?
Well, that's a very pertinent question, because it's actually a system that overlaps between the UK common law style and the continental style. That's a sort of accident of history. Mauritius was a French colony, and then it was won by the British from the French. But when the British took over, they didn't ask the Mauritian residents to change their system of law or governance, and they didn't ask them to speak a new language. So Mauritius is a hybrid of French and English law, French and English governance, and French and English language. So it makes it a really interesting place for parties from different sides of the common law, civil law divide to go to resolve disputes. And we tried to retain that diversity and flexibility in setting up the system for arbitration there.
So when you came back to the UK and started working as a, for lack of a better term, an arbitration advocate, tell me a little bit about your practice, what it is, where your clients are from, what you focus on, things like that.
Yes. The clients that I largely represent in a typical case are either states or companies owned by states, which are in business with international investors, either in the energy sector. So that's usually in oil and gas production, transport, sale, or power generation in its various forms, and power sale. To some extent, a little bit of mining, although that's not quite so much in my everyday practice. Many of those parties come from the African continent, but we've spread much more widely than that since I started at Howard Kennedy. And we also have a really strong practice in India and Pakistan and in the Middle East, and to some extent in the US, heavily relying on our relationships with other Meritas firms, in particular for that region, and really benefiting from relationships with guys like you and your colleagues in the US.
So when you say your work is based in Pakistan, are you saying that you're doing work in the UK for state actors or companies who have contracts based upon state actors in the UK? So, you mentioned you mentioned Africa, you mentioned Pakistan, you mentioned India. So is it that there is a arbitration clause in the agreement with investors that has the situs in London? Is that is that where you're coming in and doing the work?
Generally, yes. Not exclusively, but the typical case we would do is a case involving a contract that provides for arbitration in London as the place of arbitration, or the legal place of arbitration, and either provides for English law to apply or provides for the law of the place that the contract relates to. So, for example, I recently did an arbitration involving a London seat, and we physically held the arbitration in London as well, although that's flexible. You're under no obligation to hold the hearings in the place where the seat is, and Pakistan governing law. So we worked together with a lawyer from Pakistan, and we made a sort of balanced team between the English lawyers and the Pakistani lawyers, presenting arguments which relied on Pakistani law rather than English law.
So as a partner in a law firm where, fortunately or unfortunately, we're paid by the work we bring in, is part of your work, part of your pitch, to make sure that those state actors get arbitration agreements that have London as the place to where the arbitration, or the rules that govern the arbitration?
We do advocate for London as a good place to hold your arbitrations, but we
Does your corporate team, I mean, do you work with them to make sure that they have the appropriate, when people come to you, say, here's the arbitration agreement we suggest and here's why?
Yes, we do encourage our corporate teams to include arbitration agreements. They are extremely client focused, so of course they just think about what's best for their clients. And in many cases in England, if the other side are comfortable having dispute resolution in England, people will choose the courts because they're generally considered fairly efficient, reasonably neutral, high quality, good standard of judgment, and so on. It's when you have two parties that have nothing to do with England who are looking for a neutral place, which is not home turf for either side, they often end up choosing England because the strength of arbitrators that are here is very good. The institutions here are very good, and the law and support from courts for arbitration is considered very strong. So parties generally take the view that it's not a bad place to be if you're having an arbitration.
So let's break that down a little bit.
Mm.
When you have London or the UK as your where the arbitration is going to be held,
Yeah.
what institutions are your institutions named in that agreement? And if so, what are they, or what are the options, or is there one major institution that really runs arbitrations in the country?
There's a range of options, but the majority of agreements that you see will provide for arbitration either under the rules of the LCIA, the London Court of International Arbitration, which is the primary arbitral institution based in London. The second most common that you will see is the ICC Court of Arbitration, which is actually based in Paris. One of the great successes of the ICC is that they've managed to be a representative body for London arbitrations, even though they're physically sited in Paris, in France. That's because they have a unit within the institution which is entirely English speaking, entirely London focused, or Anglophone focused, I should say, and generally provides support for London arbitrations as if they were in London. Most of the time they're an email or a phone call away, so it doesn't really matter where they are physically. Sure. Then you have some sector institutions that are extremely busy and popular, but for particular types of arbitration. So the London Maritime Arbitration Association specializes in appointing arbitrators in cases involving shipping, insurance related to maritime matters, and that kind of thing. There's an organization called GAFTA, the Grain and Feed Trade Association, which holds a huge number of arbitrations regarding buying and selling of agricultural products and seeds and that kind of thing. And there's a whole range of other such bodies. You also have in London the Chartered Institute of Arbitrators, which doesn't administer so many cases, but it is often appointed to choose the arbitrators because it's considered a very experienced and neutral body for the purpose of selecting an arbitrator when the parties can't decide who it should be.
So would that be in your contract that you use them to choose? Okay, so let's backtrack to what you said a few minutes ago. Let's talk about the commercial arbitrations, the ones you are mainly focused on. Whether you're LCIA or ICC, you said one of the reasons to come to London is because the arbitrators are so good. Where are the arbitrators chosen from? Two-part question. And second, you talked about just having an arbitration under Pakistani law. Will you get arbitrators who know Pakistani law at the outset, or is it done differently?
The approach varies significantly according to whether you're having 3 arbitrators or only 1. If there are going to be 3 arbitrators, 2 of them will in almost all cases be chosen by each of the 2 parties, and those 2 will consult, and if they can, they'll agree on an individual who will be the presiding arbitrator, the third arbitrator. So when you have that situation, there's a lot of individual choice that goes into the selection of each of the 2 party appointed arbitrators.
Are they in effect really advocates?
No. There was a very interesting discussion in a case that was in the UK Supreme Court recently called Halliburton and Chubb, and as the name suggests, it related to the Deepwater Horizon disaster. And one of the things that was discussed in that case was the extent to which arbitrators appointed by a party have any qualification at all on their duty to act with complete independence and impartiality. And there was a lot of quoting of things that have been written, particularly from US commentators, suggesting that party-appointed arbitrators did have some duty to the party who appointed them, which qualified their general duties. The English court said, absolutely not. If you're appointed in England, it doesn't matter who appoints you. You should conduct yourself exactly the same, regardless of whether you're appointed by a party or an institution.
And have you found historically in the cases where you've been an advocate that those 2 party appointed arbitrators, despite their obligation, generally are on the side of the party that hired them, practically?
No, but I'll qualify that in a moment. In hearings, it is not unusual for an arbitrator appointed by a party to ask questions or seek clarification about the case in a way that helps them to understand the case being put by the party who appointed them. And I don't know to what extent this is conscious or subconscious, but from experience, that is commonly seen. I think it demonstrates the fact that when there's doubt or lack of clarity, they are motivated to ensure that any such doubt doesn't prevent a fair decision and a good decision. But I wouldn't say it reflects them favouring the party who appointed them or wanting to decide in favour of the party who appointed them. Arbitrators are supremely motivated to appear neutral because that party may never appoint them again, and other parties might want to appoint them. And one of the worst things they can do for the perception of their approach is to appear very partisan. And so the other parties think, well, this person is just a gun for hire who's been brought in to say whatever the party appointing him has said. The qualification I was going to mention very briefly is studies have been done to see where dissenting awards or dissenting opinions in arbitration come from. And they invariably come in favor of the party appointing from the arbitrator appointed by that party. So that's a qualification on the general principle that arbitrators are supremely neutral. That statistic is hard to ignore when you're thinking about that.
I will tell you, when I'm an advocate in a three-person arbitration where you have one appointed by each party, I always assume I am speaking to the third arbitrator and the third arbitrator only. And I would counter your assumption about you don't want the next person to hire to think you're a hired gun. I would argue that if you rule against the party who picked you, you may not be picked by another party because they won't necessarily think you're going to be on their side. So I think there's two edges to that sword.
I think you make a good point.
I'm more cynical than you are, I think, on this one.
Perhaps. One of the ways to win an arbitration, I always think, and I'm agreeing with you here, is to make it so that even the arbitrator appointed by the other side doesn't feel able in the final analysis to favor that party's case, because the case against is so strong, it would be embarrassing or impossible for that person to take that position in the deliberations with the other arbitrators. And that's how you make sure you win. I think it corresponds to what you were just saying about speaking to that person and convincing them.
And how about the issue of arbitrators with knowledge of foreign law, if it's a foreign law based London arbitration?
It's often the case that arbitrators are appointed who do have some knowledge of that law. It's rarely the case that the whole tribunal is from a background that corresponds to the governing law, because very often there will be at least one entirely neutral arbitrator who doesn't have the relevant legal background. The parties often will also, to some extent, I think, hedge their bets by not having a tribunal consisting entirely of people from that jurisdiction or trained in that jurisdiction, so that they have a fresh pair of eyes on the point, because either side knows that they may come across an arbitrator from that jurisdiction who has a fairly fixed view on the matter, because it's part of their legal knowledge already. If you have a neutral who's not from there, there's a better chance that you can bring them around to your way of thinking by virtue of the fact that they're coming to it fresh and they haven't necessarily considered it before.
So if you're touting the value of having an arbitration with a London-based contract, even if it's not held in London, what are you, other than the fact that they could then use you, what are you telling foreign entities, foreign states, is the advantage of going to London as opposed to, the ICC in Paris or elsewhere?
The first thing we say to any party is that if you get an award in London, you have the best chance of enforcing it rapidly, even if the other side want to be difficult and obfuscate and delay. Because if you go to the courts with a good award, the courts will confirm and enforce it very quickly. And if you try and set up weak arguments why it shouldn't be enforced or why it should be set aside, the court will dismiss those very quickly. And the gateways for challenging awards are very narrow. So the first point is, if you genuinely want your arbitration process to resolve your dispute, this is a very good place to be. The second reason, I think, is that the standard of arbitrators is high, and in most of these cases, I would suggest, when it comes to the merits, the commercial considerations, the questions about the documents that you're dealing with, the evidence that you're dealing with, what actually happened, the commercial market, the realities, are as important, if not more important, than the law itself. So you really want good decision makers on those matters as much as you want the top expert on Pakistani law or Venezuelan law or whatever it is that's coming up in the case. First and foremost, I think most parties want their case to be decided on the facts and on the contracts rather than on clever points of law. Not always the case, of course, depends which side you're on, but I think that's generally true.
So let's talk a little bit about the enforcement issue. And my understanding is that at the end of this year, at least, there'll be an advantage to going to London as opposed to elsewhere on the continent, because as part of Brexit, you had to agree that any ultimate ruling by your high court could be looked at by the EU High Court, and that runs out at the end of 2024, but obviously will still exist in places like Paris. Is that accurate?
Yes, it's correct that the effect of Brexit is that we no longer will have any supervision from the ECJ, from the European Court of Justice, and there won't any longer be any role for European law. One caveat is that in various respects, English law coped with the transition by simply enacting laws that were identical to European laws into English law, so as not to have to rewrite whole rafts of litigation in order to achieve the full transition, which would have been virtually impossible. But what it does mean is that if you're arguing about those matters, the last and final say on the question will be the Supreme Court here rather than the ECJ. So that
right. So if you're talking,
if we were, yeah.
So if you're talking about the speed of enforcement, you'll have one less layer that you have to go through in the UK than you would in Paris, theoretically.
Yes, and one less potential source of doubt and uncertainty. If you know what the English courts think, you can be confident where it's going to go. That's much more difficult to do with the European Court, which has been known to produce more surprising decisions or unexpected decisions, because it's a court that's made up fundamentally of multiple jurisdictions, jurists from a wider range of backgrounds and places.
And if you receive an arbitration award and move to enforce it in UK courts, are there limited grounds like in the US to overturn that decision? Is it difficult to overturn that decision?
Yes, it's very difficult. The grounds are, like the US, extremely narrow, but they are there and available, and I've taken advantage of them myself on behalf of clients in the past. So it's not some utopia where once you've got the arbitration award, you can put aside the possibility of it being challenged. And there are still parts of the English system which, in continental Europe, for example, they would say make it far too easy to challenge, and to do so at length with a long court hearing over a period of several months. The prime example being that even if the arbitrators have decided they had jurisdiction to hear the case, the court will review that decision de novo and make entirely a fresh decision on the point of whether the tribunal had jurisdiction. The Arbitration Act has been reviewed recently, and one of the things they decided not to do was to narrow the grounds on which you could challenge jurisdiction, so that you had to show the arbitrators got it wrong. The position will remain after the new act that as long as the judge thinks the arbitrators got it wrong, the award will be set aside if they didn't have any jurisdiction. They're trying to tighten the rules to speed it up and to narrow the amount of evidence and argument that is made, but fundamentally the decision will be the same. So I think in England it's right that the gateways are narrow and they're enforced strictly by the judges, but the policy is more open to judicial intervention than it is in France, for example.
So if I understand you correctly on the jurisdiction grounds, that would be after a case is initially filed in arbitration, you get an arbitration ruling, then there's then an appeal that says this should never have gone to arbitration in the first place. Do you have the opposite situation, which we have all the time, which is someone files in court and then you say, no, you have to arbitrate? So the court would be making a jurisdictional decision before going to arbitration, or does the judge normally then just send it to arbitration and lets the arbitrator decide the jurisdiction, or is that contract dependent?
The position here is that the judge, if seized with the matter first, will generally send it to an arbitrator. The judge does have the power at that stage to decide that in fact there's no arbitration agreement at all, or the particular matter in question doesn't fall under the arbitration agreement and therefore shouldn't be referred to arbitration. But that's fairly unusual. Most judges, if they're seized with a claim and the defendant objects on the basis that it should be dealt with in arbitration, most judges will stay the case pretty much straight away without argument and send it off for arbitration, because they know that if they decide in favor of the case going to arbitration, then the matter might well come back before the court later in any event. So they take the view they'd rather have the arbitrators make the decision first, and then the court can be used as a review mechanism rather than deciding things up front, which conflicts with the primacy of the arbitration agreement if there is one.
That's exactly the opposite of the way it works here. The judge will make a ruling on jurisdiction unless the arbitration agreement says jurisdiction is to be determined by the arbitrator.
Okay.
And then you would be in the same situation as you apparently are in the UK, which is post arbitration. You can then have a jurisdictional hearing before the court.
Yeah. So, it's created some interesting but slightly esoteric debates about what's the meaning of a matter and what matters fall within the arbitration agreement, and some courts have fallen into the trap or perhaps the temptation of getting involved in those matters and deciding them first. But I think the preferred approach is get it off to arbitration, let the arbitrators do it.
So you talked about how the English Arbitration Act was being reviewed. Where are you? What any big changes you foresee coming, or has it already made its way through Parliament?
It's almost made its way through Parliament, but it hasn't quite reached the final stage yet. And the parliamentary system in the UK, a little bit like the US, it's quite politically vulnerable in the sense that if, say, the government in the UK were to dissolve Parliament now and call a general election, that would prevent the Arbitration Act from going through in this Parliament, and it would require whichever government was elected to take it up again and put it through the process again. So we shouldn't count our chickens about this Arbitration Act, because there are reasons to think it might not make it through. But I think everyone's pretty confident because the form of the Act is largely uncontroversial, and it follows a careful path, avoiding most of the more difficult subjects that there were strong views on both sides of. So it kind of addresses the things that could be addressed with a consensus, and it leaves alone the things that were more challenging. Whether it will make any significant changes, in practice, the significant changes are that it gives an express power to arbitrators to deal with matters summarily. So to make decisions on the documents on short hearings where the arbitrators take the view that a particular claim or defense has no prospect of success. And I've always found that interesting, because arbitrators, we always hear from arbitration experts that arbitrators have such flexibility and freedom to do what they want and to reflect the justice of the case and deal with it efficiently. But nevertheless, the view's been taken that they need an explicit provision in the Act that says, yes, you can do this. I think it certainly will encourage it, because everyone's going to be talking about it. Arbitrators will be thinking about it, and parties and their lawyers will be thinking, this is something that I can potentially use to get some weaker points knocked out. So I think we may see the emergence of a new phase in arbitrations, where there's an attempt to have some issues resolved summarily early on before you get to the full merits stage of the arbitration.
So let's talk about maybe the meat of an arbitration in the UK. What type, when you file an arbitration, do you have to file a detailed statement of claim? Do you have to file witness statements at that time? You know, what is the process? Because here it's all you do is file a statement of claim. That's it.
Yeah.
That's it. That initiates it.
Yeah. It's actually similar at the very beginning of the arbitration. At the very first stage of the arbitration, almost every case is begun by a very simple request for arbitration, which sets out in summary form the basis of the claim. So it will set out in very brief form the essential facts, contracts, performance of contracts, that kind of thing, and the basis on which relief is said to be due, and an indication of the relief claimed. You certainly don't have to quantify your claim to the penny, for example, and you're not held strictly to the relief that you've put in that document. So that will start off the arbitration under the LCIA, the ICC, most other cases, and that document will prompt the appointment. So if you're nominating arbitrators, you'll actually nominate someone in that document. If the institution's doing it, you'll propose a procedure, for example, a list and strike procedure, or another procedure to resolve the identity of the arbitrators. So that's stage one. It's a very brief summary document to just kick off the process and get it rolling. The differences come in stage two, which is where the parties are required to put their case in detail. And that can take the form of a detailed statement of case, which is a pleading. It's like a particulars of claim in the English court, or a statement of case in other courts, or it can take the form of a brief or memorial, which we think of as the continental style, where you both plead your case, you have a narrative document that describes your case, but you also include with that the statements of any witnesses, reports of experts if you need them to substantiate your case, and a significant volume of documents that you're going to be referring to support your case. So you end up with a sizable, I mean, I'm holding my hands up as if I can show you how big they are. Some of them are a room full of documents, some of them are, you know, a lever arch file, but it's never just a few pages of script. You know, it's a bundle of documents and evidence that represents something that, if nothing else was said, should be able to actually establish your case and hopefully the damages you're claiming. So those are the two approaches.
So you're not required to give the witness statements before the actual arbitration, or are you? If you choose the first path, which is just laying out the basis of your case without giving the documents, the witness statements, the expert reports, do you have to give the documents, the statements, and the expert reports at some point in the process?
Yes, in that case, you will have a step-by-step procedure where you start with the statements of case, and then there'll be a designated point at which everyone exchanges the written statements of witnesses, a further designated point at which they exchange any expert reports they're going to be relying on. There may be a document production phase, which is a limited process of asking the other side to provide copies of relevant documents. In English arbitration, it's always kept to either specific documents or specific categories of documents which go to a particular issue. So just as a very simple example, you may be asking for the company's management accounts for a particular period in order to show transactions that it was doing. That would be a category of documents. In Europe, some arbitrators will dispense with that altogether and simply say it's for the parties to produce such documents as they want to rely on. Others will say, I want requests for specific documents. And by that, I mean each document to be identified individually. So a document production process, but it couldn't be further from discovery, from a full court-style process of document discovery between the parties.
So there's no, generally in arbitration, there's no depositions, there's no speaking to the other witness before the actual arbitration, correct?
That's right. It would be virtually unheard of in an English or European arbitration to have that procedure.
And are the witness statements admissible at the arbitration, or do you have to be able to cross-examine that witness?
They are admissible. If you don't make a witness available for cross-examination when the other side ask to do so, then the tribunal will attach less weight to that witness's testimony, and they'll give them less credibility. If there are genuinely disputes of fact that turn on what witnesses say in their evidence, then not calling them to be cross-examined would be disastrous. Arbitrators, I would say, are less traditionalist than judges about this, though. They'll be more open to the idea that some witnesses are largely producing documents and describing things that have been done at a corporate level. And some arbitrators will say, well, actually, cross-examining this one individual about what was happening may not be the most useful process of getting to the bottom of the case.
So have you ever thought about using, for certain witnesses that you think are strong witnesses or will appear well, have you ever thought about using, and are you allowed to use, a recorded witness statement as opposed to a written witness statement and produce that as part of your case?
I've never thought about it. The closest I've come is when a witness, for some reason, is at risk of no longer being available at the time of the hearing. And in that situation, I have previously recorded an interview with the witness on the basis that we didn't plan to use it, but if the witness succumbed to the illness that he was suffering from, then it would be available. And it would be more compelling somehow than a simple written statement, which, rightly or wrongly, and it's not always true, but sometimes are seen as largely the lawyer's words rather than the witness's own words. So
Sure.
a video in that case would have been useful. As it turned out, it wasn't necessary. He was available to give evidence, so we didn't need it. As for using it in place of a written statement, it's never occurred to me. Have you done anything along those lines?
We don't do written statements. You walk into some arbitrations, you have a limited number of depositions.
Yeah.
Generally in commercial arbitration you do, but if you do a securities arbitration, for example, under FINRA, you walk in blind. You don't know what the other party's going to, you know their claims or their defenses, but you don't know what the witnesses are going to say. So it's a totally blind cross-examination. So makes it fun, actually. But you do not do witness exchanges. You do not exchange witness statements. There are times when you have, if you have a witness who is going to be out of the country or is ill, you'll get both sides in to be able to, you basically do the arbitration questioning before the arbitration and just get the arbitrators to agree to it. And as you said, they're flexible. They're not going to say no to that as long as there's a cross-examination allowed. So that's a very big difference between English continental, even African arbitrations and U.S. arbitrations. It's very strange to us to have a witness statement. It just doesn't, it doesn't happen.
Yes, there's been strong efforts in the English courts recently to force lawyers to produce witness statements that actually represent the words of the witness, and even the professional obligations on solicitors have been toughened to try to prevent them from putting words in the mouth of the witness and drafting what they would like the witness to say. And there's some evidence, only limited, because court and arbitration are kept very, very separate in England and the procedures are very different. But there's some evidence of arbitrators wanting to see a better reflection of what the witness actually says in the written statement than has previously been the case. Because you saw, especially in arbitration, where arbitrators sometimes didn't want to come down too hard on the lawyers and seem too aggressive, you saw witness statements being put in that were beautifully written, crafted, articulated, persuasive submissions, essentially, on the case, and written by, the second engineer from this company who could tell you in great detail about his engineering matters, but probably didn't write that document. And it's not very helpful to arbitrators to get that.
Do you do work outside of, I mean, you said that you don't have to hear a UK-based arbitration in the UK, but do you do any work outside the UK for non-UK based arbitrations, and how do you get that work?
I do. I get it in a very similar way to the way that I get the work in London, which is that parties I already know, or parties who are introduced to me by mutual contacts, are looking for an English lawyer for whatever reason, because they think it will be an effective representative and someone who will understand the case. That has led to me doing arbitrations in interesting places. I've done a few in Dubai. Dubai and the UAE is becoming increasingly popular as a place to actually have hearings, because it's generally considered sophisticated, organized, safe. It's very easy to get to from countries that need a lot of visa processes to come to the UK or the US. They can get to Dubai very easily. So if you're bringing in witnesses from Nigeria, India, Europe, and the Far East, Dubai is a very easy middle ground. So Dubai's been popular lately. I've done a couple of cases in South Africa, because South Africa, for Southern African cases, you have the facilities and the resources there to run a fully fledged international arbitration. And sometimes the parties will just say that just makes more sense as a place to go. I've done a couple of cases in Mauritius, simply because of connections that I've got there, people who've wanted an English legal team for a case that they're running that happens to be Mauritius based or Mauritius seated, and a few other things in other parts of the world. And
for those cases, do you have to either be barred in those jurisdictions temporarily or permanently, or do they let you work with an attorney from that jurisdiction?
All of the jurisdictions I've mentioned let you work as an English lawyer, with or without an attorney from that jurisdiction, but we would normally do it with. We generally take the approach of partnering with lawyers from the jurisdiction in question. There are very few jurisdictions who require you to be barred locally in order to appear in an arbitration. There are still some, but it's quite unusual now. One of the provisions in, for example, the UNCITRAL model law on arbitration is that there won't be the restrictions on advocates in arbitrations that apply to advocates in court proceedings or other legal work. And it's designed to encourage accessibility and freedom of choice of advocates, in the same way that some parties, if asked to be represented by an advocate from a particular jurisdiction, would feel that they couldn't be represented as effectively as they could from an advocate who is either local to them or somewhere more familiar that will represent them.
So that's an interesting distinction, because obviously the U.S., is a signatory to the United Nations law. But if you go to any state you're in, you have to check the state law, because there are many of them, and it's not complicated. Many of them require you to be temporarily barred to do an arbitration. Some of them have an exclusion for an arbitration as long as you're barred in some state. I have actually walked into a arbitration hearing against a state where I had to get the deputy attorney general to get me barred that morning because they had told me I didn't need to be. And then when I got there, the arbitrator said, "Oh no, you need to be." So that's interesting that you have a UN rule and our states are all relatively independent. So
yeah, that's fascinating. There's another issue that sometimes comes up in my work, which is that it's sometimes suggested that local content laws, which require the involvement of local people in certain industries, apply to the representation of parties in arbitration. So, for example, in Nigeria, there's a case that suggests an arbitration was entirely unlawful and against the public policy of Nigeria because the personnel involved, arbitrators and lawyers and so on, were not Nigerian. And it was a matter that related to the Nigerian oil and gas industry, where you have local content laws that say all or some of the people involved must be Nigerian. I think that's been overturned now, but it still comes up from time to time, and people will ensure that they have local lawyers instructed, partly to make sure that there's no suggestion that they're breaking some kind of rule like that.
So I know this probably changes, but who generally are the arbitrators? Are they barristers like you? Are they, retired lawyers? Are they? I'm sure in certain cases you have subject matter expertise, like the second engineer, if it's relevant, especially in cases like yours. But generally, where are they chosen from? How and who are they?
In England, they're a mix of barristers, some former barristers who now sit full-time as arbitrators, solicitors and lawyers in law firms who are not barristers, but they are international arbitration experts, and they take appointments as arbitrators. And you also have that category retired from counsel practice who simply sit as arbitrators. And then we have retired judges. That's a category that's increased in recent years. It used to be quite unusual for judges to go into arbitration. It's become more common because I think more judges, having sat in the commercial court, which is the court that specializes as part of its work in dealing with arbitration cases, come out of that experience with a really good understanding of how it works. And as long as they come out of that experience not expecting to do arbitrations as if they were a judge and just sort of carry on the same practices, it's generally a very good experience to have them, because they're very experienced and decisive and practical about moving cases forwards whilst also doing justice. So that can be very good. We do have a significant body of arbitrators who are not lawyers, who are subject matter experts, engineers, architects, and financial experts in some cases, but that's slightly more unusual. In my recent career, I've only seen one arbitrator in the last few years who hasn't been a lawyer by training.
Any specific training that you need, or any licensure you need in order to be an arbitrator?
Or no. Okay. It's a simple answer. You can go from selling ice creams one day to being an arbitrator the next day if you want.
Okay.
There is training available. The Chartered Institute offers a lot of courses, and there are the other institutions and other bodies also offer a lot of courses training arbitrators and giving them experience, but there's absolutely no formal requirement.
So to be on the roster of the Chartered Institute, you have to go through their particular training or?
Yes, okay. You're absolutely right. In their case, membership indicates a certain level of training, and senior membership indicates a higher level of training and experience. And when you get towards the top, there's a certain number of arbitrations you have to have sat on as arbitrator before you can qualify for the Sure. higher levels of Chartered Institute membership. In other bodies, your level is often indicated by your involvement. So you can be a member without much experience, but if you're going to be, for example, on committees or councils or boards or courts, that will generally indicate that you're a more experienced practitioner, but it's more informal. with those institutions.
And do arbitrators also, I don't know the role of mediation in UK or even in arbitrations, do arbitrators often act as mediators as well?
Some do, but it's not a typical practice. Most arbitrators will say, I'm an arbitrator, mediation is not my skill so much. Some will cross that divide and do both. Many mediators will say, I'm a mediator, that is my skill. I see it very, very differently from that of being an arbitrator. And they wouldn't want to dilute that specialism by trying to do both things. And there are a lot of very good mediators that we take advantage of here who are very effective in a very different way from arbitrators. You know, it's a very different skill set.
So let me turn away from kind of the commercial arbitrations for a second. And I don't know if you follow what's been happening in the United States, but as the Supreme Court has adopted more and more pro-arbitration rulings, corporations have expanded their arbitration clause and to shrink the number of claims that can be brought in court. And one of the things that corporations did was they said you can't bring a class action. Yeah. You have to you can arbitrate, but you can only arbitrate individually, and that's been upheld. But plaintiffs' firms are not dumb. And so they started filing mass arbitrations. So you can have 10,000 claims in a commercial, or a consumer situation, where to even start the arbitration, you're going to get a bill for $7-8 million just to start the process because there's so many individual claims. Yeah. I understand that class actions are very different and much more limited in both the UK and the continent, but have you seen anything like that happening within the market in London or on the continent?
We haven't really. The big difference between the US and the UK and most European systems is that if there's an arbitration agreement in a contract between a consumer and a commercial supplier or commercial company, that arbitration clause is not binding unless the consumer reconfirms their agreement to it at the time that the dispute arises. So if I buy a product from a commercial supplier in my personal capacity, and something goes wrong with it, I can choose to go to court to resolve those disputes, and I can't be forced to go to arbitration, even if there's an arbitration clause in the contract that I've entered into, unless I'm invited to go to arbitration and I agree at the time there's a dispute. So in the UK, consumers have that freedom of choice, and so they still generally resort to court action, sometimes group litigation, as we've generally called it, or just single individual test cases, which are then used to guide other cases, that's traditionally been a preferred approach of quite a lot of judges in our courts. So we're fortunate or not, possibly not fortunate in the business world, but they don't have the ability to put arbitration agreements in consumer contracts, unlike the US situation.
How about employment contracts?
Employment contracts also, generally speaking, an individual employed won't be held to an arbitration agreement in an employment contract, because we have a specialist tribunal system in the employment tribunal, which individual employees are entitled to take advantage of if they choose to do so. So it really is a strongly consumer protective attitude to arbitration here.
So let's to wrap this up, let's turn back to your large commercial arbitrations, and I know you have told me in the past that you believe the arbitration system in the UK produces a high standard of justice. I'd be interested to hear why you think that, and you know, how you came to that conclusion, other than the fact that you are a practitioner within the arbitration system.
Yes. I think we have a very advanced and effective nursery for arbitrators here. We have a very busy legal system, hearing disputes from all over the world involving all sorts of legal systems, all sorts of people, all sorts of cultures, industries, and so on. So you have this body of lawyers who are very familiar with dealing with cases that are not domestic, don't only involve their own law, and involve a variety of issues. You also have a good quality judiciary who set a very good example for lawyers then to follow as arbitrators, so that hopefully arbitrators in this country, or who have practiced or trained in this country, generally follow a very good standard of independence, decision making, generally due process, and a just approach to the parties and hearing the case. So that's where I think it comes from. One of my sadnesses, and I'm giving away my politics here to some extent, one of my sadnesses about leaving the EU was that prior to leaving the EU, London was benefiting from the fact that lawyers from anywhere in Europe could come and work here. And so we had this influx of different legal traditions and cultures, and people with other languages and other experiences coming in and joining the legal profession here, which really enriched it, and helped to do what I'm describing, which is churn out great arbitrators who are really open-minded and flexible. And it's a shame, in my humble opinion, that we closed that off. Obviously, many lawyers still come here, and there's a visa process, and it's not too difficult. But I liked our open attitude to anybody from the whole of Europe being able to come in and work. So that's where I think the heart of it is, the real source of good arbitration in London.
Thank you. I appreciate that. Before we wrap, is there anything that we haven't talked about that you think would be important for listeners to understand?
The only final comment I would make is that it's a sadness for me that London looks a lot to Europe and works with Europe and cooperates with Europe in arbitration terms, and even beyond to Asia. You know, Singapore has become an enormous center for arbitration and is extremely busy doing cases from Asia and all over the world. It's always been a bit of a sadness for me that there's a slight gap in the middle of the Atlantic Ocean, and we do things quite differently in the US and in Europe. And it's reduced to some extent our ability to work together in arbitrations with US lawyers. It hasn't eliminated it, but it's just made it slightly more difficult than it would have been perhaps if we had slightly more closer arbitration cultures. So I'm keen to keep on working on breaking that down and allowing culture to flow across so that we can work together more. And one thing I would say is, when you're in an arbitration, it should be flexible enough to bring learnings from other places. So we can learn from the US about how you do things. You were talking to me earlier about some ideas and different approaches that you have, and vice versa. So I think we should work on that and try and break down that barrier a bit more.
As always, sage advice from you, Duncan. I appreciate your time. Thank you very much.
It's a pleasure. Thank you.